Last week, we had a call from a lady who has recently suffered an injury, and she maintains it's through no fault of her own, but she has heard how expensive it can be if you end up in court challenging a case and perhaps potentially losing that case and having to pay not alone your own costs, but that of the defended party. So we thought we'd get some advice. There is something called the Injuries Resolution Board. It used to be known as the Personal Injuries Assessment Board, but they've changed the signs over the door and perhaps a little bit more. David Keane is one of the experts with Tormeys Solicitors in Athlone. David, good morning.
Good morning, Will.
So, distinguish for us between the Injuries Resolution Board and going the court route. What are the pros and the cons?
Yeah, so I suppose just to say at the start, all personal injuries claims now since 2004 start in the Injuries Board. So regardless of whether you want to go the court route or not, you have to start with your personal injuries claim with the Injuries Board. So it's a state body that was set up in 2004 to deal with claims. It's set up, I suppose, according to their own website, to support fair, prompt and transparent resolution of personal injuries claims without the need for unnecessary litigation. And I suppose it was set up as a way that maybe people could bring claims themselves without having to go to a solicitor. But I think as we go through it, you'll see that there's a lot of kind of pitfalls that people need to be aware of if they are going to do it themselves. And obviously, our recommendation would be to take advice at certain stages of it, if not for the full way of doing it.
I remember at the time, as you say, 20 years ago, Senator Donny Cassidy was one of those who was influential in setting it up. And the aim was, because car insurance premiums were skyrocketing in those days, that having this more streamlined process, taking some of the legal expense out, would result in lower overall payouts, not necessarily compensation components. So let's get into whether that has worked. That's step one. How do you, first of all, fill out the paperwork to register that there is an injury?
Absolutely. So I suppose one thing to remember even before you go filling out the application is what's known as the statute of limitations. So essentially you have 2 years from the date of an accident to bring a claim, and that's very important. So your injuries application must be complete and importantly accepted by the Injuries Board within that 2-year period. Now it's a bit different for a minor. So a child would have 2 years after the date of their 18th birthday. So for example, if a child got into an accident when they were 10 years old, strictly speaking, they could bring the claim up until they turned 20. But I think you're better to bring them as quick as you can, really.
And is there a form, structure you fill out, or is it a case of sending in a letter?
Yeah, so there is, you'll get a paper application form if you're doing it yourself. You download the application from the website. Otherwise, if you go to a solicitor, there's an online portal that we can use to fill out these forms. So just to fill out the form, the first thing you'll need to have as well, obviously bearing in mind the statute, is a completed medical report from your treating doctor. So generally that'll be your GP, or if you have more serious injuries, it could be from a consultant. And the Injuries Board application itself, then you set out your basic personal information, the details of the accident, what injuries you've suffered, details of the respondent, so that's the person you're suing. Just by the way, the injured party is known as the claimant. You'll have to disclose any previous or subsequent injuries or medical conditions. And again, it's very important to be upfront in your application, as it can come back to haunt you if the matter does move to court proceedings if you haven't disclosed a previous injury or accident. And next thing, a barrister could use that to say, well, look, Judge, this person clearly isn't very truthful, and it just, those things
undermines
can get away from you. So, you must sign a claim declaration just confirming that the application is fully accurate, and you send it in. And again, you send it by post with an application fee, I think, of €45. And generally, when you're getting a medical report, they can cost anything from €400 to €600, sometimes more, depending. A consultant will usually be more expensive than GP.
And at this stage, if you're deciding you're sticking with the Injuries Board route, are you best advised to put in as much detail as possible, all the reports, detailed descriptions, or does that bit come later?
Yeah, so you generally just put in one report. It would cost you a lot of money if you were looking for reports from every expert you thought you might need. So your reports go in, and so in the assessment process, which we'll get to next, the Injuries Board have the option of getting you assessed by further doctors. So we dealt with the application. So again, in the assessment. So,
by the way, timeframes. So you send in your paperwork, your €45, and how long might you be waiting for a reply and eventually your assessment?
So you might get, let's say within a couple of weeks, you'd get a reply from the Injuries Board to tell you whether your application was correctly filled out. If it wasn't, for example, you didn't have you didn't sign a claimant declaration, it could come back to you. So it's very important to make sure that you do get notice of it being fully complete, because that's when the statute clock stops running. So until you have that confirmation from the Injuries Board, which hopefully in a couple of weeks, you need to be sure that your statute's correct, because again, that can make it very difficult down the line. So then you'll get another letter then from the Injuries Board confirming that they have sent the application to the respondent, so the person you're suing, and telling you that the respondent has 90 days to decide whether or not they want the claim to be assessed. So generally it'll be the respondent's insurance company that will decide that. If they decide after the 90 days not to have it assessed, then the Injuries Board can do no more. It issues an authorisation, and your only recourse then is court proceedings. If they decide to let it go into the Injuries Board process, that's when the assessment process starts. So generally speaking, through statute, the Injuries Board is supposed to assess claims within 9 months of, let's say, the respondent consenting to the assessment. But they have a discretion to extend that to 6 months, which will give you a total of 15 months at that stage. And from our own experience in the office, I haven't seen any be assessed within the 9 months in the last couple of years. Generally, you're going towards that 15-month bracket.
And is that by virtue of the volume of claims?
I'd presume so.
So it's really up to the respondent, the person you're suing, to decide whether the matter is heard by the board or whether you end up having to take a case.
Yeah, that's true. Look, and generally speaking, again, if a respondent consents to the assessment, it might mean that it's a case where they've accepted liability, so that they're accepted there in the wrong, and all they want is the Injuries Board then to decide how much it's worth. But that's not always the case. But then on the flip side, if they reject the assessment, it might be a case where liability is disputed, and which means they're not accepting it. You're going to have to go to court for a full fight if that's what you want to do.
They may look at the form and, depending on the quality of the information, determine whether they may have a good chance defending it in court, in which case put it back to you.
Yeah, exactly.
So I imagine you're going to give the answer yes here, but would it be advisable to have a solicitor fill out that form using the correct terminology, the strength of the arguments?
Yeah. Well, look, I suppose there's no arguments really. It's you give brief enough information in the application, but I do think from a point of view of making sure every relevant piece of information and personal history is in it, I do think it's very important to have a solicitor involved.
But do you have to establish why the respondent is at fault in the application form?
No, so the Injuries Board won't deal with liability. They won't decide who's at fault. So all you'll be saying is what you're alleging happened. The Injuries Board will make no determination on that.
So let's assume the respondent is willing to have the board assess. They concede the liability or whatever. Then how does that assessment process work?
Yeah, so you're in that 9 to 15 month period, and the Injuries Board they'll send you for an independent medical examination generally. So if you had, let's say, a broken arm, they might send you to see a consultant orthopaedic surgeon. If you also had an element of mental health issues, you might send you to see a consultant psychiatrist. And at the end of that process, then the Injuries Board will have their reports. They'll also look for your out-of-pocket expenses, so they could be fees you've paid for your GP, to A&E, medication, and loss of earnings. The Injuries Board puts all that together, and they come up with an assessment based on your injuries, based on the personal injury guidelines that come out in, I think it's 2021. And so the compensation will generally be based on how long it took you to reach a significant stage of recovery from your injury.
But for instance, over loss of earnings, that could be a considerable amount depending on how long somebody is out and how much they're paid. And is there any arm wrestle as such where the defendant, the respondent says, look, that should have been healed in 3 months and they were out for 6?
Yeah.
Is there room for that?
No, in the Injuries Board there's not. There's no back and forth. It's the Injuries Board. You said that the claimant puts everything into the Injuries Board, and the Injuries Board make a determination. If the respondent aren't happy with any part of it, they're entitled to reject the award when it is released.
So if there's any contentious element to the incident, it's more than likely going to end up in court.
Yes, that appears to be the way it'll go.
So the costs involved in the Injuries Board process, you mentioned the €45 initial application. Is there anything else?
Well, and your medical report fee. Look, if you're doing it yourself, that's what the fee is. Now, obviously, solicitors, if you are going to a solicitor, will have their own fee for it. I couldn't put a figure on it.
Depends on the complexity.
Depends on the complexity of it and the hours worked.
So are there limits to how much can be awarded by the board?
No. Well, just on the basis that general damages in Ireland are capped at approximately 500 or 550,000 euro. So that's the most general damages, which are for your pain and suffering. And then special damages are what can top up any sort of a general damage. So like that, the loss of earnings, and in more complex cases like the ones you'd hear in the news that run into millions, that's generally where people need kind of care for the rest of their life, and that's how you'd get to that sort of a level. But general damages wise, it's no more really than 500,000.
And are the courts constrained by the same limits?
They are in relation to general damages. Now I'm using 550 as a ballpark, but it's around that figure.
So you mentioned there are pitfalls. Delay obviously seems to be one of them.
Yeah.
What else might be a reason not to do it?
Not to bring the claim, or not to do it yourself?
Well, both, I suppose.
I suppose, like, if you think you're entitled to bring a claim, I don't think there's any reason not to bring it. But any reason not to do it yourself is just, we do it on a day in, day out basis. We know what needs to be done, where issues can arise, and we can advise people best on them on a case by case basis. I think when you're doing it yourself, you don't have that same security.
And then if the case is contested and it ends up going to court, then you have to make, I suppose, as a solicitor, far more in-depth investigations to establish, is there liability, the degree of it, if there's also an onus on the person to take due care, and whether they've been in some way complicit in their own injury, and that could be quite expensive.
Yeah, it does happen, and it is difficult to jump into a case which has already been going on probably for a year or two, nearly in the injuries board. But look, you do have to do it, but as you said, it takes a lot more time to read into it because you haven't had it from day one.
And the cost in a typical personal injury case, if it goes before the court, are we into 5 figures?
Well, it depends what court you're in. The district court generally tends to have a scale, so that'll be cheaper. Then up into circuit and high court, like, you can go into tens of thousands really. And obviously, if you end up losing, you end up paying everybody else's costs too.
A lot to take in. So again, let's recap. It's now called the Injuries Resolution Board, and I assume there's a good website and resource there with the relevant forms.
Yeah, there is indeed, yeah.
Or, if you want to take the legal route, tormeys.ie, and David Keane can give you advice. David, thank you.
Thanks very much, Will.